Your Honor, this is Timothy Jordan. It looks like this morning we received a signed order to withdraw from Mr. Jordan's cases.
It's only one case, according to Madam Clerk.
The order was only filed into one of the cases.
It has 3 case numbers on it: 23 CF 1983, 23 CF 1982, and 21 CF 2345.
Okay,
It hasn't been filed into the 1980.
okay. But the order had all 3 case
It
numbers.
did. I'm looking.
So
at the
Mr.
order.
Jordan's now represented by the Regional Conflict Council?
I believe so.
Okay, so we're going to wait until 1:30 and thinking that Ms. Jakewood will be here? Or
I have no idea if she's going to be here.
do you want to enter a denial?
I was
from
going to say if
Mr.
the
Jordan?
court wanted to enter not guilty pleas for Mr. Jordan.
Okay,
These are some pretty hefty charges. I wouldn't anticipate a plea today anyway, so if we would want to just continue it to the 11:13.
okay. Mr. Jordan, they're handing you a copy of the information. That is the charging document from the state, says what they're charging you with. I'm entering a denial on your behalf. Your Regional Conflict Counsel, Ms. Jakewood, will come see you in the jail, and I'll see you no later than November 13th. But if Ms. Jakewood wants to file a motion before that date, she can do that, okay?
I received a letter in the mail from the court saying that I got a hearing with Judge Ketchel on the 11th of October.
Okay,
It was in Ketchell's division, and then it got transferred to this.
okay. So now I've got all of your cases. So you
Okay.
don't have the hearing in front of Judge Ketchel. But good question. Ms. Jakewood will meet with you. Again, if you want to file a motion before that date, I'll see you then.
Because I filed a writ of habeas corpus before I left prison, and I've heard nothing on that.
Okay? If you're represented by counsel, that would be a nullity.
No, I was in prison. I was represented by nobody.
What I'll do is I'll text Ms. Jakewood as soon as I'm done with my clients
Thank
today and let her know, so she'll come and see you as soon as she can make available time.
Okay, good. Thank you, sir.
And she'll talk to you about whatever the habeas issue is or anything like that, okay?
Okay.
All right.
Rafael Lopez Rodriguez.
Thank you.
Your Honor, we might need to pass on the 1:30 docket. I think we have an interpreter.
Okay. I'll see you this afternoon.
9.
Right.
McCovery.
Thank you.
Discovery, I'll come up to the jail and go over it with you. Yeah, he's not gonna make an offer today. Okay. Doesn't mean there might not be one down the road. It's just as of today. Your Honor, this is Willie McCovery. I talked to Mr. Gomez. The state is not in a position right now to be making a plea offer to Mr. McCovery. There is a 1-count information. We will waive the formal reading, enter a not guilty plea, and just ask that this remain on the November 13th docket.
Okay. Mr. McCovery, I'll see you no later than November 13th. But if the state offers you something you want to accept before that date, Mr. Kleins can set that hearing before then. If Mr. Kleins wants to file any other motion, we can hear it before then.
Yeah.
Yes, sir.
All right.
Thank you, sir.
All right, man. I'll come see you when I get that.
Oh, okay.
All right, man.
Jimmy McDonald.
Thank you.
Your Honor, this is Mr. McDonald. Been pretty busy this week. I didn't get a chance until yesterday afternoon to file a not guilty plea, but there has been a written not guilty plea filed in 23 CF 1880. Just to cover the record, we will orally enter a not guilty plea also.
Okay. Mr. McDonald, I'll see you no later than November 13th.
Yes, sir.
Thank you, sir.
I'll come up to the jail when I get this.
I've got Kevin Morales, Mr. Klein. I believe this is the bond hearing.
Good morning. I'm doing well. How are you?
I'm as good as can be expected.
Yes, sir.
Your Honor, Mr. Morales is before the court today on a motion to reduce bond in 23 CF 1936.
Is that on at 2:30?
It was noticed for a hearing at 1:30.
Oh, it was what was added, right?
Right.
I've got it. Good. And I did my homework, Mr. Morales. I read the motion to reduce bond, saying that right now it's a $10,000 cash or professional.
He's not in custody on the VOP case for
Okay.
some reason, so I'm just asking the court to reduce.
Mr. Kleins, I'm up to speed and also made a copy of the arrest report.
Yes, Your Honor. So Mr. Morales actually, he's got two cases. He's got this 23 CF case, which is the motion. However, he has this VOP in 22 CF 2511. He is not actually technically in custody on that 2511 case. So the entire motion basically is asking the court to reduce the cash or professional bond in the new law violation to signature bond. If I could just take some brief testimony from Mr. Morales.
Yes, sir. Mr. Morales, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth? So help you God.
Absolutely, sir.
You can put your hand down. Thank you.
So, Mr. Morales, if you're released on bond, where are you going to be living at?
I'll be back at 326.
Okay, and who lives there?
Right now, my quote-unquote friend is staying there, but I'm going to be throwing him out when I get there because he's been stealing from me while I've been locked up.
Okay. Now, was that house that belonged to your dad?
It belonged to my father. He recently passed away earlier this year.
Okay. What do you do for a living?
Well, since my father passed, I've been unemployed. We had a family business.
What kind of business was that?
I built pool enclosures.
Okay. Now, have you ever failed to appear for court?
Never.
Your Honor, I'm sorry, can I just stop? Can I request that this be heard at 1:30? With all due respect, we printed this docket at 9:20 at 11:18 a.m. It wasn't on this docket. So I just need a little bit of time to prepare. At 1:30 would be fine, but I just need a little bit of time to be able to look up his prior record and stuff like that to be able to do it.
I have no problem.
And I apologize for having to
No,
ask
sir,
that, but.
not a bit. No, it did come late, that's for sure. Okay, I'll see you this afternoon. Okay.
I'm sorry.
We'll continue this.
Scott. I apologize.
It is what it is.
So do I go back to the jail and come back?
No. They're just going to put you back there, and then at 1:30, thereabouts, you'll come back out here. All right?
Pearson? Sure. She's on your 1:30 and 2:30 docket, Judge.
Okay, thank you. Good morning, ma'am.
Yes, Judge. Good morning again. I have Ms. Pearson to my left. This will be a change of plea, Your Honor. We're here on 3 cases, the 2020 CF 3263, the 2021 CF 1162, and the 2023 CF 1902. She's going to admit the 2020 and the 2021 case are all violation of probation. She'll admit, and then the new law will be a plea no contest, Your Honor. She'll be adjudicated guilty on all the counts. It'll be revoke and terminate the probation, credit for time served. There will be $200 for the cost of prosecution in the VOP cases. There'll be $515 in court costs and $350 for defense costs, Judge, if I may approach with the
Yes,
plea
sir.
form.
Thank you. Ms. Pearson, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you, ma'am. You can put your hand up. Ms. Pearson, have you ever been convicted of a felony in the past? No? Okay. Do you understand that if I accept your plea that you will be a convicted felon?
Yes.
Okay. If you had sufficient time to talk to Mr. Koch about the ramifications of that,
Yes.
do you still wish to enter the plea?
Yes.
Okay. And Ms. Pearson, I start there because I think about what's the biggest downside to you that I see initially. With a revoke and credit for time served, that's not a downside, but the label of a convicted felon, I just want to make sure that you understand that.
Yeah.
Okay. Ms. Pearson, did you read the plea agreement?
I did.
Do you understand it?
Yes.
Did you sign it?
Yes.
Ms. Pearson, I do accept your plea. You're adjudicated guilty. Your prior supervision is revoked and terminated. You'll need to pay the $200 cost of prosecution, the court costs, total of $350 public defender's fee. How long will you need to pay that amount of money before it goes to a civil lien or judgment?
3 to 6 months.
I'm sorry?
3 to 6 months if possible.
Okay, 6 months, how about
Yes.
that? Okay. So if you fail to pay it within 6 months, it'll go to a civil lien or judgment. Okay? Thank you, ma'am.
Okay.
Next one, Dina Robeson. Ms. Pearson, go straight to that. Dina Robinson.
Thank you.
Please.
Hello, Ms. Robinson.
Hello, how are you
Good, how are you? It's always good to see your smile.
today? Thank you. Yours also.
Judge, may I have just one brief moment?
Sure. Okay.
There is an information file as of yesterday, yeah.
As of yesterday. So that new law, they filed on it yesterday. Okay.
So, Mr. Koch, since an information has not been filed, then I'll,
The information has been filed, Your Honor.
okay, Madam Clerk.
No Robinson?
Yes, in 1872.
I don't have it.
It is docket number 26. Oh, no, I'm sorry, that's
No?
Sandy.
We'll make sure, this could be another issue. We'll make sure that it gets filed, Your Honor.
Okay.
Yeah, I know, and I signed it. Yeah.
So you think you can get it filed before this afternoon?
I'll send an email right now to make sure that it's filed, hopefully. within
Ms.
the-
Robinson, I'll see you this afternoon. We'll see if they can get that filed by 1:30, okay?
Okay.
Good. Thank you, ma'am.
Take this, yes, ma'am. I'll see you this
Rachel, how you
afternoon.
like pushing this rope?
Yeah.
Yeah.
Next, I have Randall Pendergraft.
Okay.
Yes, Judge.
Yes, sir.
The state attorney, they did offer me a 90-day jail offer. They still need to reach out to the victim in the case, Judge. So could we set this case for October 9th for a plea?
Yes, sir.
So October 9th? Yes, sir.
So I'll see that, and you're accepting the information?
Yes, Judge.
You do the formal part of that.
Yes, we'll enter not guilty, wait formal readings, Your Honor.
Mr. Pendergraft, I'll see you no later than October 9th. Thank you, sir.
Gage Pritchard.
Excellent. Yes, Your Honor. We'd like to enter a not guilty and wait formal readings, and if we can keep this set for that pretrial, November 13th.
Yes, sir. Mr. Pritchard, I'll see you back here no later than November 13th, okay? Thank you,
Thank you,
sir.
Your Honor.
Next, we have Ricky Ramsey.
Thank you. Hello, Mr. Ramsey. Yes, sir.
Yes, Your Honor. The state attorney did file formal charges in this matter. Defense, we also filed with the clerk system and provided the state a sworn affidavit of the alleged victim in this matter that wishes to drop the charges. I explained to my client, of course, that it's up to the state attorney ultimately.
Right.
I did request on behalf of my client that the bond be reduced, and the state did object. So today, there will not be a bond hearing, but I will follow up with some paperwork and get a bond hearing scheduled.
Good.
So for today, Your Honor, I'd like to enter not guilty and waive formal readings of the charges.
Okay. So, Mr. Ramsey, your underlying case is continued, or at least it's set for pretrial on November 13th. But if Mr. Koch files a motion to set bond, he can set that a lot sooner than that. So I'll see you at that hearing.
But can I say this, Your Honor, one thing?
Just know that everything's being recorded.
I want it to be recorded.
Yes,
That's
sir.
why I'm going to talk to you. First and foremost, Your Honor, I didn't know I could be charged for breaking into my own residence. I never knew that.
Okay.
Is that
just-
a new, I
just-
need
again,
clarification?
Mr. Ramsey, hold on one second. Just listen to me a minute. And then you can say whatever you want to if you want to. But,
Okay.
you know, I get defensive because, or anxious, when you start talking about the facts of your case, because the state's sitting to your right, everything's being recorded, can be used against you. There's probably not much of an upside today for that because there's nothing for the court to really decide at this point. And so I don't see much of an upside, if any, and I see a heck of a downside. So before you say anything else, I'd talk to Mr. Koch away from the microphone.
Okay. I just wanted clarification on that, that's all. The charge, I didn't know a charge of that nature.
Okay. As far as the charges, you understand formally what they are?
That's part of my problem. I was asking for clarification on that.
Okay. Mr. Koch, what are the charges against your client?
Yes, Your Honor. And I did speak with my client yesterday and provided him a written copy to keep.
Good.
But it is count 1, burglary with assault or battery, first degree, and it's a PBL. Count 2, domestic battery by strangulation, third degree felony, Your Honor. And count 3, criminal mischief, and first degree misdemeanor. And that's what you are charged with formally.
Okay.
And Mr. Ramsey, it's a great question because that's the reason why we have first appearance is
Right.
due process to tell you what you're in jail for. So I'm
Right.
glad you asked.
Yes, sir.
Okay. So I'll see you no later than November 13th. But if Mr. Koch files a motion before that, we'll have a hearing before.
You gonna have a motion before then?
Oh, yeah.
Thank you, Mr. Ramsey.
All right.
We have Adrian Sanders.
Thank you. Hello, Mr. Sanders. Good, how are you? Yes, sir, Mr. Koch.
Yes, Your Honor. As of yesterday, I didn't see any information filed for Mr. Sanders. And that,
The information was filed yesterday.
okay.
So do we want to bring Mr. Sanders, Madam Clerk, do you show us?
It's in Carlos.
Oh, good, okay, you got it.
Your Honor, may I just request an offer, just on the record? So they did file a charge yesterday, and she'll tell us the offer, and we'll have time to discuss. You know.
Yes, sir.
Judge, the offer from the state for Mr. Sanders is an adjudication of guilt, 36 months probation, standard court costs, substance abuse evaluation in 30 days, and beginning recommended treatment within 60, random analysis, 24 hours of community service, and driver's license suspended for 1 year, and a letter of apology to Deputy Jennings.
Your Honor, may I just have a brief moment?
Yes, sir. And the adjudication is guilt or withhold?
Yes, Judge.
Guilt.
Your Honor.
Yes, sir.
If we could pass that up, and I could have an opportunity to speak in the back
Okay, good.
this afternoon.
So, Mr. Sanders, I'll see you this afternoon.
Yes, sir.
Okay? Good.
Thank you, sir.
Thank you.
I'll see you in a little bit. You take this one.
And last, we have DeAndre Seymour Short, who's unrepresented.
Okay, thank you. Information. Hello, Mr. Seymour Short. Please, if you'll come to the lectern. This is 23 CF 1856. Mr. Seymour Short, do you wish for me to appoint the public defender if you qualify financially?
No, sir. I'm hiring an attorney, sir.
Okay, you're going to hire private counsel?
Yes, sir.
Okay, yes, sir.
Judge, if we can recall Mr. Seymour Short this afternoon, I have notices to provide to Mr. Short.
Okay. So, Mr. Short, and I hesitate based on what the state may, okay. You want me to continue his arraignment? Or do you want me to do the arraignment and then just bring him back for service? Let's do the latter. Okay, so Ms. Seymour Short, you've received a copy of the information, the charging document against you, aggravated battery using a deadly weapon, domestic violence battery. That's why you're in jail. That's why you're here. I'm setting your pretrial conference for November 13th. If you're going to hire a private attorney, do it sooner than later, where they can start working on your case. If you decide that you can't afford an attorney or you're not going to hire a private counsel, please fill out the financial affidavit at the jail, and then the public defender will be appointed if you qualify, okay? So don't wait on that. Let them help you start working on your case. They will keep you here until the state brings you back out to just serve you with some additional papers this afternoon about 1:30. And then you can give those to your private attorney, okay?
So if I got a public defender, will I still have to stay here?
Yes, sir, there's nothing, you don't just immediately get out if the public defender represents you. Your public defender or your private counsel would need to file a motion for bond or bond reduction to try to get you out, and then we'd have to set a hearing on that.
Yes. I only asked that because I have medical issues. I've been sitting on a bench since 8 o'clock this morning. I have rods and pins inside of my hips and my bones, and I already been complaining to him about it. That's the only reason why I asked that, sir.
Ms. Davis, any other way to get Mr. Short served?
No, Judge, I need personal service.
Okay.
It's HFO, HVFO, and PRR that I need service.
Okay, and so we can take Mr. Seymour Short first thing at 1:30, right when I come back on the bench, bring him out and serve him? Okay, so Mr. Seymour Short, I'll see you at 1:30, we'll take you first, okay? Rachel, will you make a note of that?
Yes, Judge.
Thank you.
Judge, may we recall William Vordenbaum?
Yes, sir.
Judge, last on the record, we'd set this over to 2:30, but I've had a chance to speak to Mr. Vordenbaum while the court was completing the rest of the docket.
Okay.
And obviously, keep in mind that I was appointed about 15 minutes ago. If this was a fact question only, well, then I would probably say, let's go to trial next week, given that there are issues related to law that I would need a substantive hearing date with Your Honor. If we refile any motions to suppress or anything like that for Mr. Vordenbaum, I'm going to request a continuance so that I can complete depositions. There were no depositions completed by Mr. Vordenbaum when he was pro se.
Any objection from the state?
Judge, at this point, we would object. We have subpoenas out. Everything is ready to go for Tuesday, excuse me, because Monday's a holiday. Everything's ready to go for trial. Mr. Vordenbaum has already filed on his own, motion dismissed, motion suppressed. Those issues have already been litigated before this court. It's a driving license suspended or revoked. At this point, the discovery has been sent to Mr. Vordenbaum. He has clearly reviewed it, and as Your Honor has seen, Mr. Vordenbaum presented to the court an arrest report and the video regarding the case. So at this point, we're prepared to go to trial on Tuesday.
Okay, thank you. Mr. McKinney, or let me ask the state, has Mr. Vordenbaum moved for a continuance in the past? I mean, I know we've granted continuances based on his motions, but I don't know if he's really ever technically moved for that. That's almost a rhetorical question, Mr. Vordenbaum. It's not going to be dispositive for the court's decision. Very easy for the court to say, Mr. Vordenbaum, you did not just ask for an attorney today to delay your trial. There's no question in the court's mind that your motivation wasn't just a delay. There may be other people that appear in front of the court, and that's true. I know you want this resolved. It's the first time you've had an attorney. Ms. Davis?
Judge, it looks like, Mr. Bordenbaum has filed multiple motions before, to reschedule a court date. There was a continuance in July, which would have been prior to the motion hearings. So, let's see, July 17th. Without pulling court smart, but I'm quite positive I did not ask for that continuance.
I understand.
I quite well know what cases I asked for continuances on, and this was not one of them.
Yes, ma'am. And I'm certainly not saying the state did. I wouldn't make that representation. Mr. Vordenbaum, I do grant your motion for continuance. First time you've had counsel. And again, I don't find it dilatory at all that you didn't do this just to delay your trial. I know you want to go to trial. You want this resolved.
And Judge, we'll be ready for trial in November if we're unable to resolve the matter.
Okay. So, Mr. Vordenbaum, I'll see you back here November 13th at 9 o'clock.
Thank you.
Stay in touch with Mr. McKinney.
To make sure we're clear, Judge, the offer for credit, adjudicating credit for time served, that will expire after our court dates in October. If we are going to trial in November, then that offer is not going to remain open.
Okay, so if Mr. Vordenbaum appears here on November 13th, there's not going to be any offer from the state.
No, Judge.
Okay. Mr. Vordenbaum, talk to your attorney about that. You've got to decide what's in your best interest. Listening to him, his advice, and you decide if it's best for you.
Yes, sir.
Okay?
Judge,
See you no later than November 13th.
Judge, and hearing that while we're on the record, I will need deposition dates from the state prior to those dates in October that the offer will expire.
I understand that's your desire.
I think
Yes, sir.
we can probably get it scheduled for this point Wednesday, we'll get a deficit now.
Sounds like a plan. Thank you, Judge.
Okay. Thank you. Ma'am? What motion? I denied the amended motion to suppress. Yes, ma'am. Thanks, good question. Yes, sir.
Judge, just want to let the court know, about 5 minutes ago, I did receive a text from Mr. LaPella, and he stated, and I quote, "We have to object to continuing the case at this stage." I don't know what the court would like to do. I anticipate what's going to happen is, because he's going to file a motion to allow somebody to appear via Zoom, Florida rules of criminal procedure are extremely clear that both parties have to agree to that.
Okay.
You're
Okay.
going to deny
Let's
that.
go into the substance of it.
Yeah.
I understand strategically what you're seeking on Mr. Mueller. Okay. Okay, let me think on it some, and I'll send y'all an email, okay? Good. Thank you. We're in recess until 1:30. Thank you.
All right, please.